Good afternoon.
Good afternoon.
Waiting for my man. Okay, we're good. All right. Good afternoon and welcome to the Environmental Law Institute. My name is Brett Cordy. I'm the director of our Associates Department, which is the ELI department that brings you webinars and educational programs like today's. You've joined us for the basics of land use law, the third in our 2017 summer school series, which runs every Thursday through July. And we highly encourage you all, if you haven't checked out the rest of the series, to do so. It's on our events calendar. You can register for all the events, joining us in person or on the web. For the audience in the room, if you have a question at any point during our presenters' talk today, please let me get you this microphone. That way our web audience can hear. They're just here to capture the audio. You don't need to talk right into it. It's small enough room that we don't need to amplify it too much. And if you're participating through the web, you can submit your questions through the go-to box. I think we're going to be taking questions throughout the seminar today, so send them as soon as you think of them, and we'll get to them when we can. Video and audio recording of today's talk is going to be available on the web within the next week or so. Our speaker's full bio is available on the events page, but I will briefly introduce our speaker today. We're so grateful to have Gus Bauman, who is of counsel at Beveridge and Diamond. Gus's practice focuses on land use and environmental issues. He advises clients on comprehensive planning, project development, and natural resource regulation, among other things. Before joining Beveridge and Diamond, Gus was counsel and legal department director for the National Association of Home Builders. He's been deeply involved in Supreme Court land use and wetlands cases for over 35 years, including landmark decisions on regulatory takings of property and development exactions. Gus is also a leader in regional transit planning here in the DC metro area, chairing task forces for Metro and working with the Maryland Greenways Commission. Gus, thanks so much for being here this afternoon, and I'm going to hand it right off to you.
Great. Thank you, Brett. Well, hi, everyone. And I know we're down here for 2 hours, and so just so you know, I've been in government. I thought what we do is go around the room. There's about 110 people on the webinar, but for the people here in the room and for the people on the webinar, there's maybe 20 people here in the room. But a good value of this, I think, is that when this is all done, someone here may say, oh, you're working over in there. And so I thought we'd just go around the room and everyone just say quickly, you know, where are you? Whatever you want to say. And then you may make a connection with someone here in the room when this is all done. Plus, it's of interest to me, frankly, to know. I mean, I've got all these names here, but it's just paper. So then what I would do is just give you a couple of minutes about my background to give you a sense of that whatever your plans are, they're probably going to change, whether you want them to or not. And just to know that whatever your career plans are, you could go off in one of 6 directions, and it's not the end of the world, whatever direction you go in. You know, it's not the end all and be all, even though it feels like that. I understand that when you're like 26 or 28 or 38 for that matter, it just seems that way, but it's not. So I thought I'd take a minute about, you know, how I got to this table, because it's not the usual route. And then we just dive into this. Now, the outline that I did that you have, I just used this as a skeleton. This is a bare bones outline that gives you literally the raw facts of land use law and land use system in the United States. And then what I'm going to do is basically use this as the framework and then do color commentary about what all this really means and how it works in the land use and environmental world. And then again, as Brett said, feel free to ask me questions while I'm talking, because one of my faults is I will digress and it happens, and then your question will pull me back in where I do that. So that said, if we could just go around the room, that's all right, Brett, and everyone just, you know, say who you are and like where you are. I understand from just looking at the paper, there's a variety of backgrounds, and so it could be useful for all of you to know as well as me. So we'll start on this side of the room.
Jim Potter. I'm with HUD's Office of Environment and Energy. I'm a trained planner, but I do I'm the lead on environmental justice, and I also handle their noise regulation.
Well, there's no more EJ, so you don't have to do that anymore.
Yeah, it got easier.
It got easier. Yeah.
I'm Scott Troy. I just recently licensed attorney, kind of jumping in on the second career.
Great.
I'm Michelle Castelline. I'm a law student. I'm working at the Association of Fish and Wildlife Agency this summer.
I'm Clara Summers. I'm a legislative assistant at Earth Justice.
Sure. Hi, I'm Victoria de Los Casas, attorney Aiken Gump, environmental section.
You're in our old offices. You bought our offices 25 years ago. And by the way, we got the better part of the deal.
Hi, I'm Brian Williamson. I'm a law student, summer associate at Aiken Gump. I'm doing a lot of their environmental work.
I'm James Carlson. I'm a law student as well. I am externing with the Department of Defense General Counsel's Office, Environment and Installations this summer.
Okay.
I'm Ian Fauché. I'm an undergrad interning with Environmental Law Institute right here.
I'm Sarah. I'm also an undergraduate intern at ELI this summer.
Hi, I'm Kim Johnson. I work at the Theodore Roosevelt Conservation Partnership.
Hi, my name is Elisa Meal, and I just graduated from Bates College, and I'm currently looking for work in urban planning and environmental policy.
Hi, I'm Lauren Monis. I'm an undergrad at Brown, and I'm interning at ELI this summer.
Hi, I'm Kate McCormick. I am a Rising 3L at Georgetown, and I'm a law clerk here at ELI this summer.
Hi, I'm Bridget Groats, and I'm a law student at the University of Washington, and I am also interning at ELI this summer.
Hi, I'm Ethan Blumenthal. I'm a law student at University of North Carolina, and I, too, am a law clerk here at ELI.
I'm Elizabeth Platt. I'm interning at the National Association of Clean Water Agencies.
I'm Molly Gotch. I am a Rising 2L at Georgetown Law, and I am interning at American Rivers this summer.
Great. I think that's everybody. And then for those on the web, there's 110 of you, but we're not going to ask you to introduce yourselves. So before we dive into the subject, I came out of law school in the recession of 73, 74. So my first job was I got recruited into a large government agency in Maryland that rings the suburban, it's called Suburban Maryland, but it's the counties that ring Washington, D.C. And it's a land use conservation agency. And so I was hired right out of law school to go to the general counsel's office there. So did a lot of land use and environmental stuff for that agency. And then, I got recruited into a big trade association to do the same sort of stuff. It was a national trade association. So I did that for a bunch of years. And then I got recruited into the law firm that I'm at now, Beveridge and Diamond. And then so started doing that. But then what happened was the powers that be in the county in which I live, called Montgomery County, Maryland, decided, they decided to make me the chairman of this land use parks agency, which was a full-time position. So I had to resign my partnership with the law firm and go into the government position, the same position that I held in the general counsel's office many years before in the 70s. And then did that for a bunch of years, and then went back to Beveridge and Diamond. And throughout all of those years, I was always involved in government and politics, and still am. And I guess the moral of the story is that I never planned any of this, just so you know. None of it was planned. And when I graduated from law school, like I said, it was in the middle of a very bad recession, nothing like the Great Recession. Nothing like that. But 73, 74 recession was really bad. Nixon was in the White House. I don't want to bore you with all that. But it was a grim time, but I look back on it. It was the halcyon days when I look at today. But in any event, the point is none of it was planned, and each thing led to something else, and they were all interesting jobs. So whatever you end up doing, since all of you are, I understand, most of you are in the positions you're in, I always say to people when they come and meet with me about this sort of thing, just take the first opportunity that comes knocking if it feels right, because you never know where that will lead. Whether it's a government agency, and it doesn't have to be federal government. It could be state government. It could be local government, whether it's a firm, whether it's an NGO. It really doesn't matter, unless it's really important to your mom or dad. And then you got to deal with that. That's another whole thing you got to deal with. So with that said, let's talk about land use. So the outline, this outline that I wrote was written actually for judges. I was asked to do a series of conferences for American judges, both state court judges and federal court judges, because they don't get a lot of land use cases. But they know is, for those who are lawyers or law students, they know contract law, tort law, criminal law. They know nothing about what we're talking about. So in any event, this was written for judges to explain to them what is land use, because that's always their first question. If you ever have a case before a court, what is land use? What is zoning? And then you have to explain, well, do you live in a house? Yes, I do. Does it sit on a lot? Well, yes, I think yes, or it sits on a lot. Okay, that's land use, and it's zoning. And then you start from there. So let's start at the beginning. The most important thing to know is what I have at Roman numeral 1, that land use controls are an inherent exercise of the police power of the state. A lot of people lose sight of the most basic things in American law, and that is really basic. So the inherent police power of the state resides with the federal government and the state government. Local governments are merely creatures of the state governments. So just so you know, while when you deal with local officials or local planners, they all think that they're the end power, and actually they're not. Local governments are merely instruments of the state, and what that means is that the state could eliminate local governments if the state wanted to. They could eliminate and take back all land use controls, zoning, comprehensive planning, if they so chose, because only the state government is sovereign and the federal government is sovereign. And so this is important in the land use world because much and most of land use controls in America are done at the local government level. And when you deal at the local government level, you are really at the grassroots of American democracy, the good, the bad, and the ugly. It's all there. And you have to sometimes remind people at the local government level, you know, you exercise these powers at the sufferance of the state government and at the sufferance of the American Constitution and the state Constitution. This is something they never think about. And you may have to remind them of this at times, depending upon what you end up doing. So moving on to Roman numeral 2, what do the state governments do? Well, what they have done in this country, all 50 state governments have enacted statutes that enable their local governments to do comprehensive planning and zoning and subdivision controls. Those are the big 3. Every state is a little different, but the important thing to know is it's all done pursuant to state statutes. So never forget that when you're dealing with in the weeds at the local level of government and you're dealing with some zoning issue or a comprehensive planning problem, and everything I speak about, it doesn't matter what side of an issue you're on. I'm just speaking generically about the way it all works and whether you're representing an interest group, an applicant to do something with their property, the government agency. You just got to know the framework and what the limits are. Because if you're lawyers, you often have to tell your client what the limitations are, which they don't want to hear sometimes. But you have to remind them of that. That's one of the jobs of a lawyer, is to remind the client of what the law says. Because you will find often people in government think the law is them. I know that's not your experience, but it's just the way things are. And so when you look at the framework, we're dealing with these enabling statutes in all 50 states. And those statutes lay out what the powers of planning and zoning and subdivision controls are at the local government level. And some states keep a lot of the power in the state government, and other states give a lot of that power away to the local governments. And so one thing to know that could be useful to you in the future is to speak this in the most general terms. They're either called Dillon rule states or home rule states. A Dillon rule state is spelled not like Bob Dylan, but D-I-L-L-O-N. And it's a Dillon rule state, and it's named after a judge from Michigan in the 1880s who basically handed down a ruling that a lot of states follow, and basically says this: when it comes to exercising the police power within the state, and when you're exercising the police power, that includes zoning controls, planning, subdivision controls, everything to do with land use regulation at the local level. The Dillon Rule states say the local governments only have as much power as the state government expressly delegates to the local government or is necessarily implied. And to give you an example, in the Washington region, a Dillon Rule state is the Commonwealth of Virginia. I never make the mistake of saying the state of Virginia. It's the Commonwealth of Virginia. I understand that. They're special, so it's a Commonwealth. Maryland, on the other hand, is a classic example of a home rule state, which basically means the state government long ago within these enabling statutes basically say, here are the general limitations of what you can do in terms of regulating land at the local government level. And you can necessarily imply all kinds of things from this. And then the courts interpret those statutes. So you're either in a Dillon Rule state or a home rule state. You just need to know that fundamental thing if you're ever engaged in land use practice anywhere in the country. By the way, the District of Columbia is sui generis. Because it's not a state, the system of land use regulation here is wholly different than from everything that goes on in the 50 states. I won't get into the details about how it's all different, but it's radically different the way land use regulation is done in DC as it is in the 50 states. So I'm just going to focus then on how it's done in the states.
How do the territories compare?
You mean like Puerto Rico?
Yeah.
Well, if you're in Puerto Rico, rule number one, know how to speak Spanish.
Yeah, I got that one the hard way.
Okay, you did?
Yeah.
Yes, okay. Because if you go down there and you don't, you know, it doesn't matter how smart or wise or handsome you may be, it's irrelevant. Okay, so just know that. Don't go into Puerto Rico to do land use regulation unless you can speak Spanish. But there, you know, the few territories that we have, it's like tribal government. It's just whatever their rules are. But Puerto Rico, because it's Spanish background, it tends to follow, you know, what's done in the 50 states, generally speaking. And then there are exceptions, which is why if you ever do anything down there, always hook up with a local law firm. You know, if you're coming out in New York or Washington or LA or Miami, just, you know, that's called a practice tip from experience. Okay. Now, turning to Roman numeral 3. So, the constitutions. Okay. This is something local folks often don't like to hear, but the federal constitution and all the state constitutions have provisions in them that protect private property rights. This often clashes with exercise of land use controls. You can see how that would happen. So the private property rights provisions in the American Constitution, and it's mirrored in all 50 state constitutions. There's the Due Process Clause, there's what's called the Takings or Just Compensation Clause, and there's the Equal Protection Clause. All three of these come into play in one form or another, depending upon what issue you may be dealing with. Again, no matter who you're representing, the government, an applicant, a third-party interest group, doesn't matter. So, turning to these key clauses, the Fifth Amendment of the U.S. Constitution is very important in American land use because in the Fifth Amendment, that's where it says that private property cannot be deprived. A citizen cannot have private property rights deprived without due process of law. It's the Due Process Clause. Fifth Amendment goes on to say, nor can private property be taken for public use without just compensation. There, you've got a multiplicity of phrases, all of which there are mountains of court-made law. What is private property? What is public use? What is a taking? What is just compensation? That provision in the Fifth Amendment is replicated in all 50 state constitutions, as is the Due Process Clause. Due Process Clause, that's the provision that gets to is a provision enacted by a local government or state or federal, it doesn't matter, but in land use, we're going to just talk about local government because that's where 90% of the game is whatever the local government did in some zoning dispute or subdivision dispute or project application battle, whether this building goes here or there, whether it's going to be 20 stories or 3 stories, whether you can build anything there, something there, nothing there, whatever. The due process clause is all about the sense of, is the thing that they did arbitrary and capricious and unreasonable and fattening. It's not fattening, but it's arbitrary, capricious, unreasonable. That's what due process is all about. And that's called substantive due process. The abortion decision, Roe versus Wade from 1973, that was a substantive due process case, all right? Because it was all about, okay, we're going to take substantive due process concept of, is what the government doing, is it arbitrary, capricious, unreasonable? That's the concept of the substantive due process clause. Now, there's a thing called the procedural due process clause, and that is something that everyone understands. And procedural due process is, did the affected property owner have notice of what the government was contemplating doing on their property or in their neighborhood? Did they have notice of this? And did they have a right to a hearing to speak to it? Those two fundamental things, notice and public hearing, are fundamental in all land use regulation across the United States. And there are mountains of case law about what it means to have notice and a public hearing and a right to be heard. Whether you're the applicant for something to do on some property, or whether you're the neighbor who is complaining about the application that's pending before the local government agency. So that's procedural due process and substantive due process. The Equal Protection Clause comes in sometimes in land use regulation, and this is the classic case. It goes on all the time. Imagine you're at a 4-way intersection in a city or a county, and all quadrants are equal in every way. They're the same. If there's an environmental something on one, the same environmental resources on all 4 quadrants. The whole concept of the Equal Protection Clause is that you don't treat folks differently from similarly situated folks. And this comes into play in land use where, and I know this never happens in the towns and cities that you all come from, but where the local government makes the decision that, yeah, they get to build the shopping center over there on that quadrant of the intersection, and then the other 2 quadrants of the intersection, we're going to just regulate it down to open space through our zoning power. That'll be open space, and we'll just regulate it that way. And then the 4th quadrant we'll treat in some other way. The people who get what's called downzoned to open space, when the property just like theirs at the other quadrant gets to build a shopping center, that is a classic Equal Protection Clause issue. And let me say this about land use regulation. Everything is fact determinative. It's always based on the circumstances of the situation, because as you all can imagine, circumstances can be different in different parts of the jurisdiction you're dealing with, whether it's a town, a city, a county. But the purpose of it is whether the local government is over a town, a city, or county, they're supposed to treat everyone the same way who are similarly situated. That's equal protection. The 3rd constitutional clause, the one that gets all the press attention, the one that's the sexiest, the one that's the most contentious, the one that's most fun, is the takings clause. And books have been written about the takings clause and articles. And just the other day, the Supreme Court handed down another takings clause decision. Don't ask me about what they did because I've already written about it and it's unbelievable. But what it does is guarantee everyone in this room and on the web a career for the next 30 years. Trust me, it does. Because instead of making the rules clear, they made them so murky that they'll be litigated for the next generation. And they will be. So no matter what side you are on of all of this, you're going to be busy because of that decision. But anyway, I digress. See, I got to be careful. But it was a takings clause decision. And the takings clause is that provision of the federal constitution and all the state constitutions that says, nor shall private property be taken for public use without just compensation. Now, in the Precambrian era of American jurisprudence, the takings clause only meant eminent domain, meaning the government has the power to take anyone's property for public use. It's a sovereign power. It resides within the state government and within the federal government. Local governments do not have sovereign power. They think they do. The mayor always thinks, hey, you know, it's like that scene in Ghostbusters, right? Where the mayor is addressing the Ghostbusters. He thinks he's got the power of God. And there's Bill Murray basically explaining, not really, not really. And he wasn't even a lawyer. Think about it. Remember? He said, cats and dogs will be, you know, okay. So the takings clause, though, comes into play not just with eminent domain, where the government can take someone's property. It has to be for public use, a library, a park, a school, whatever, a highway. And the Constitution requires when you do that, government, you must pay just compensation to the property owner. Okay, everyone understands that. And it was built into the Fifth Amendment of the Constitution, and every state has replicated it. But then in the late 1800s, the Supreme Court of the United States said, well, you know, they had started getting cases about where dams would get built. And property that wasn't supposed to get flooded got flooded. And property owners and their lawyers began to argue, you know, this is like a functional equivalent of eminent domain. You didn't exercise eminent domain. You didn't file a lawsuit in court and say, we condemn Joe's property over here for the dam project. But basically, when all the water ran across Farmer Jones's ground, they went into court in the late 1800s. These cases began to happen, and they said, this is like eminent domain. There's this takings clause in the Constitution. We should get just compensation. And the U.S. Supreme Court said, you know, you're right. So then they handed down the second component of the takings clause, and it's what's the physical invasion test. That is, if government does something that physically invades, and sometimes the court decisions will say physically occupy a person's property, that is a taking. It is therefore compensable. Physical invasions. Now, this may sound esoteric, but it's not. In the 1980s, there was a Supreme Court decision, and this is classic American land use regulation. In the city of New York, cable TV was coming into being. Apartment buildings are all over Manhattan and throughout New York City. And so the legislature of New York passed a statute that said, because of cable TV, all landlords throughout New York State will now start attaching cable TV facilities to apartment buildings. Okay, well, one owner of an apartment building in New York City, she took great umbrage at this. She said, that is a physical invasion of my private property, and I should be compensated by the state for this statutory imposition. And this got litigated at the Supreme Court, and Justice Marshall wrote an opinion for the court that said, you know what? That is a physical invasion. That is, he said, the thing can be no bigger than a bread box, which was the cable thing attached to her apartment, but it could be no bigger than a bread box, physical invasion, and that means taking. It's a taking. Now, then the second question always is in the takings case, always question number two is, if a court finds a taking has happened based on a land use regulation enacted by state or local government, what is the compensation? Well, the compensation here would be possibly very small. Okay? The point was, a physical invasion can be a lot of things. It doesn't have to be the dam caused the water to flow over Farmer Jones's property. It could be something like modern land use regulation, attached cable TV facilities to private apartment buildings. It can be lots of things. I don't have time to go through all the examples, but the point is, if you can show some kind of physical occupation, you can make a claim for a physical taking. And it may be that the compensation award is very small. It could be large. It depends. The third kind of taking, the one that has led to litigation since the 70s, as recently as last week, is a regulatory taking. And a regulatory taking is at the heart of a lot of land use stuff, because it's about the question, and the Supreme Court did not resolve this question until basically 1987. So, again, that's relatively recent time, in which the Supreme Court said, well, if a land use regulation, like a zoning restriction, or something like that. The land use regulation goes too far and has a major impact on a private property, that too can be called a taking. It doesn't have to be a physical invasion. It can be regulation. If you're representing government, it's important for you always to say to the court, this is a mere restriction on use. If you can get the court to say this is a mere restriction on use, you win. Government will win. So if you're a government lawyer, always got to get the judge to say this is a mere restriction on use. If you're the property owner's lawyer, you never utter the word mere and you never utter the word restriction. What this is a regulatory taking. We can't do anything with our property. So the Supreme Court since 1987 has been handing down decisions trying to interpret what all this means. So what I've got here for you at the bottom of page 1 of the outline are the 3 tests that the court has come up with for what a regulatory taking could be. The first is the easiest test of all, that the government regulation goes so far as to economically basically wipe out the use of your property. The classic example is from a case out of South Carolina courts called the Lucas case. And that's a classic example that's the easiest for everyone to understand and for the courts to grasp. And that is a restriction placed on 2 lots on the coast of South Carolina in order to protect the coast from damage created by hurricanes. And there were a lot of houses along there. They handed down a statute that basically said, no more houses are going to be built here because every 10 years there's a hurricane, they all get knocked down, et cetera, et cetera. And then Mr. Lucas, David Lucas, said, well, I got these 2 lots and I bought them and they're zoned for a house on each lot. That's what the local zoning says. I can put a house on each lot. Now, with this environmental restriction, I can't do anything with these 2 lots. That is a regulatory taking. That got fought over in the state courts of South Carolina. And in the end, the U.S. Supreme Court said, and they've said this in a pile of cases, but this is an easy case to explain because it was 100% wipeout that he was claiming. And it was 100% wipeout. Everyone's, they all said, yeah, that's right. You can't put a house there and it's zoned for a house. You can't put a house there. So yeah, it's 100% wipeout. The Supreme Court said, it doesn't matter what the public purpose being advanced is. That's not what the takings test is. In fact, the Supreme Court assumes that the public purpose being advanced is a valid and good public purpose, protecting the shore from hurricane damage, a fine public purpose. The point is, they said, the whole point of the takings clause in the United States Constitution, as well as the state constitutions, is to make sure that individuals don't bear burdens that should be shared by the public at large. That's the heart of the takings clause. And therefore, they said, it's been taken by South Carolina, you must pay just compensation for the 100% wipeout of the 2 lots. The punchline, by the way, which was never reported except down in South Carolina, it's always fun to find out, by the way, when you start reading cases to find out when they remanded, find out what happens on remand. It's enlightening. So this is what happened in the famous Lucas case, which is a very famous land use case, because the South Carolina Supreme Court said, that's not a taking. We're doing this for good public purpose. Hurricanes. And U.S. Supreme Court said, that's not what the takings clause is about. So they remanded back to South Carolina. And then the South Carolina courts are going to figure out, well, what should be the just compensation? Is it a lot? Is it a little? That gets fought over. So it got remanded back. But the South Carolina then said, well, now that we own these 2 properties, because we've taken them by regulation, they auctioned them off to the highest bidder for development purposes. When the press inquired about, you just spent a fortune litigating this precise issue throughout the state courts of South Carolina and at the U.S. Supreme Court, and now, and you made all these wonderful arguments, but now that, the shoe's on the other foot, you sell them off for development purposes. And the state simply said, and this is what any rational property owner would say, we have to recoup our investment. And that's what happened in the Lucas case. But that is 100% wipeout. That's unusual. Now, look at the next test. This is the test that is more normal. That is, it's not 100% wipeout of use. It is something less than that. And the Supreme Court has said over and over, if you have a substantial diminution in value and use of property, then you do a balancing test. And this came out of a Supreme Court decision called the Penn Central case dealing with Grand Central Terminal in New York City back in the late 70s. And it's a three-part balancing test. And this is like with the more typical takings case in the regulatory takings context, which is you look at the economic impact on the property owner, you look at the interference with that owner's distinct investment-backed expectations, and you look at the character of the government action. The final one is a nice way of saying, what is the public purpose being advanced? Now that's really a due process kind of test, but they threw it in here as part of the balancing test for regulatory takings. And this is what so much litigation across America is about when a property owner says, they largely took the use of my property, but yeah, you know, I can use some of it. But over here where all those wetlands are, that they just reduced me to nothingness, you know, I'm wiped out 60%, or I'm wiped out 70% or 80%. And here's the thing to know, another practice point. These cases are to be litigated in the state courts. And the state courts are very different. And the reason is because even though, and you may be saying to yourself, yeah, Bauman, but you said that all these things, this takings clause and everything, it's in the Fifth Amendment of the United States Constitution, as well as in the state constitutions, and that is true. But in 1985, the U.S. Supreme Court handed down a policy decision that basically said, well, with these regulatory takings cases in the land use world, this came out of a case in Tennessee that I was involved in that was litigated in the federal courts before a jury. When it hit the U.S. Supreme Court, they said, you know what? Because the states have what are called inverse condemnation laws, which is another way of saying the reverse of eminent domain. Eminent domain, the government is suing you, taking your property, but they have to pay you for the public use of the taking. Inverse condemnation is the property owner is suing the government, saying that some regulation that they've done takes the use of their property. So literally, you're switching who the plaintiff and defendant is. In an inverse condemnation case, and in this Tennessee case, it was the property owner suing the county in Tennessee, saying their zoning and planning and subdivision regulations basically took the use of their property. U.S. Supreme Court said in 85, you know what? Because the states all have the same provisions, you should bring these cases in the state courts and exhaust that system, because you very well may get just compensation for a regulatory taking under your state legal structure, and therefore you don't come to the federal court in the first instance. This is a way of trying to keep a lot of land use cases out of the federal courts. That's what's going on here. Despite that decision from 1985, which has been roundly criticized ever since, the Supreme Court has not walked away from that. So what you need to know is these cases generally are brought in the state courts, like the Lucas case from South Carolina was brought in the state courts of South Carolina. This case just decided the other day by the U.S. Supreme Court, a takings case. That too was brought in the state courts. So what you need to know is you bring these cases in the state courts. And so if you're in the state courts of California and you're representing the property owner, you may as well slit your wrists, because you'd basically have to prove almost like a 95% wipeout to win that balancing test. If you're in the state courts of Texas, hey, it's Texas. So, even though these tests, the words are the same, it depends upon what state you're practicing in as to whether or not the courts are more open to the government side of the takings question or more open to the property owner side of the takings question. Now, if you're going up against a federal agency or whatever, then of course you're in federal court. Then it's easy. I mean, you don't have to sit there with a client and explain, well, we could go to federal court and these are all the things that could happen, or if we could go to state court. One of the things that government often does, local governments do this all the time, the property owner will properly bring a regulatory takings case in their state court. The government then will often have the case removed into federal court and then file an immediate motion to dismiss because you can't bring a takings case in federal court. They used to get away with that across the United States until recent times when federal courts are saying you cannot, if you're the government, transfer a case from the state court to the federal court, a takings case, and then file a motion to dismiss and say, oops, look what we found. This case has been filed, is now in the federal court. You must dismiss it under the rule from this 1985, it's called the Williamson County case, Hamilton Bank versus Williamson County. I'm trying not to give you citations. I don't want to bore you with that. And I'm trying to give you just the system and the way it all works. But everyone calls it the Williamson County rule from Williamson County, Tennessee. But the federal courts are increasingly saying, no, you can't play this game, local government. We've seen this too often. You just can't do that anymore. But what it illustrates for you is that we have a dual legal system in this country. That's the point. We have a federal system and a state system. And with land use, you could be in either one when you're going up against local or state authority. If it's a takings case, you should be going into state court. But thereafter, anything could happen depending upon what the defending government does. With due process cases, substantive due process cases, federal courts have often said, we prefer that you bring those substantive due process cases against local governments dealing with land use regulations. We prefer you bring them in the state courts. So we're going to make it real hard for you to prove a substantive due process violation in the federal courts. This idea of arbitrary, capricious, unreasonable. Equal protection, I'll just touch on very quickly, and that is they are rare, but when it happens, the decisions are clear, both from the U.S. Supreme Court and the lower courts. If you have similarly situated properties, then they should be treated the same. Now here's the sticking point. In American law, property is deemed to be unique. So it's very hard to convince a court to say these two properties are the same. It's very hard to do. Don't get me wrong, it can be done, and I've done it. It can be done. It's just hard because there's this concept that, well, every property is a little different from every other property. It's like, we've got 5 kids and we love them all, but they're all slightly different, even though they may be the same. You get the point. The last thing I want to touch on is eminent domain itself. Because A, I'm supposed to touch on it according to the thing that I read that ELI put out about what this is all about, but also because the Supreme Court handed down a decision in 2005 which got an enormous amount of attention called the Kelo case, K-E-L-O, Kelo versus the City of New London, Connecticut. And it was a very famous case, and it's a wonderful metaphor for what governments should not do. By the way, these land use cases taken by the U.S. Supreme Court only takes about 2% of the cases knocking on its door. And to have a case accepted by the Supreme Court, 4 of the 9 justices have to vote to take a case. All right, so you have to have 4 justices to take a case, but you have to have 5 to win when you've got 9 justices, of course. But so it takes 4 to take it, 5 to win. Kelo versus City of New London was a 5-4 decision. And it was an eminent domain case. So it was not a regulatory takings case. It wasn't a physical invasion case. It was direct condemnation. And the decision that came down in the Kelo case was that what does it mean to say that nor shall private property be taken for public use? What does public use mean? The traditional test of public use, which governments across America always use, was the traditional concept of public use. It's going to be for a park, a highway, a dam, a school, real public use. In 1954, the U.S. Supreme Court, dealing with a case that came out of Washington, D.C. called Bauman versus Parker. It was an urban renewal case, the Southwest waterfront. That's the site of the Bauman versus Parker case. There, the Supreme Court had to deal with urban renewal in the 50s and into the 60s. And it was suddenly, we're going to condemn all these properties in this part of the city we're going to wipe everything out and start over again. And you can imagine what would happen. They would declare an area blighted and say, this is a blighted area. The legislature has called it blighted. That is the public use being advanced to cure the blight. But what happens if a property owner has a perfectly fine property? There's nothing blighted about it. She's just caught in the middle of the line that was drawn. And that's what happens in all these eminent domain cases. That's what happened in Bauman versus Parker. And in 1954, Justice Douglas said, well, if they draw that line and you got a wonderful property and there's nothing blighted about it, but you're in there, we defer to the local government and the local legislature. And after all, they do have to pay you just compensation. So in other words, what they said is public use can also mean public purpose. It doesn't have to be actual use. Because in Bauman versus Parker, think about it, they're condemning property and handing the land over to another private interest to put up buildings, private buildings, office buildings, apartment buildings. That's what happened with the Southwest Waterfront. That's what L'Enfant Plaza. That's all Bauman versus Parker territory. Fast forward to today, well, 10 years ago, 2005, Kelo versus New London, Connecticut. New London, Connecticut declared an area of its city as blighted. They made a deal with a huge pharmaceutical company, Pfizer, to come in and build a big factory and create all these jobs. Suzette Kelo had a very nice house facing the water, and she said, my house is not blighted. This is a home that I love. This is a violation of the takings clause, a violation of eminent domain. In a bitter decision, 5-4, with a stinging dissent by Justice O'Connor. But the 5-person majority of the Supreme Court said, well, in light of Bauman versus Parker, Justice Stevens said, we're constrained to say what the City of New London is doing here is for the public purpose of creating higher taxes for their budget, which they desperately need for the City of New London, Connecticut, and is to create thousands of jobs, et cetera, et cetera. It's not necessary that everything within that boundary be blighted. And after all, we're constrained by precedent, and public use, yes, can mean public purpose. And yes, all of this land being condemned will be handed over to the Pfizer pharmaceutical company. That was the plan. Now, the problem was there never was a plan. The city said they had a comprehensive plan to do all of this, but they actually didn't. And in the end, Pfizer never came. Meanwhile, they exercised condemnation. Kelo's house was condemned and moved. Compensation was paid. But what it led to, and this is what's important about the story, is because of the bitterness created and the enormous press attention this case took, it was this single woman in her little pink house, literally, it's a little pink house, up against Pfizer Pharmaceutical, which in the end never came to New London, never built the plant, the jobs were never created, because there never was a real plan, despite what the government had said. Legislature after legislature in the United States, including in California, all across the country, states have said, now, henceforth, eminent domain in our state, when exercised by the local governments here, it has to be for public use. You cannot just condemn someone's private property in order to hand it over to another private party interest. And if we do that, they have handed down through the state legislatures across the country all of these things that must be done in order to accomplish such a purpose. And then on top of that, a lot of state Supreme Courts after Kelo began reinterpreting their takings clause to say takings, when used for eminent domain in our state, Michigan, the states Supreme Courts that did this went on and on and on. It's a litany of states have all said, no, it's public use. It's got to be public use. So eminent domain changed radically since the Kelo decision. And ironically, the government won in Kelo. But in the end, a lot of governments lost the use of the power of eminent domain. And just to give you some sense of the situation that was at issue there, and is still the burning issue across America. In the Kelo case, in the friend of the court briefs filed there, you had a friend of the court brief filed by Jane Jacobs. Now, I don't know if you people know who Jane Jacobs, okay, you do.
Yes.
But Jane Jacobs is one, she wrote The Death and Life of Great American Cities. And in the 1960s, for those of us, who were doing stuff back then, and there are periods between 68 and 69 that's kind of foggy for me, but in 61, she publishes The Death and Life of Great American Cities. That was a remarkable book that's still used today in terms of how should cities be viewed, how should they be regulated. The very next year, Rachel Carson publishes Silent Spring. The very next year, The Feminine Mystique is written. I mean, the 60s, I just got to tell you, it was fantastic in so many ways. I can't get into it, but it was really great in so many ways. But Jane Jacobs filed an amicus brief in the Kelo case saying this is what urban renewal has brought us to. And she's been screaming about this since the 50s when she was fighting Robert Moses in the city of New York with all of his stuff. She files a brief. NAACP files a brief in the Kelo case because they were saying, look, the people who get stuck with these things are the poorer neighborhoods always, and often neighborhoods of color. And that's what's been going on since the 50s. So they filed a brief. The Hispanic Alliance files a brief. This use of eminent domain is something you all need to be very sensitive to because it has led to more anger and conflict than that you can possibly imagine. And a lot of local governments still don't get it. So if you end up working for a local government, one of your jobs is to just sensitize them to there is a right way to talk with property owners and communities, and there's a wrong way. New London, Connecticut did everything wrong. When you read the record of how they did what they did and why the U.S. Supreme Court took the case, heck, why the Connecticut Supreme Court took the case, New London, Connecticut made every mistake in the book. They just ran roughshod over citizens. They ran roughshod over communities. They said, this is for the public purpose. We made a deal with a company, and this is for the good of everybody. But what it really was not just a job-creating thing, but a tax-creating thing. And they lost sight of there's a right way to plan, and there's a dangerous way of planning. And Kelo case never had to happen. Most local governments are wise enough and smart enough to practice eminent domain the right way. But the Kelo case was so notorious that it's cited all the time, and you have to say they just did it the wrong way, which is why the Connecticut Supreme Court did what it did, the U.S. Supreme Court, even the majority opinion. If you read, for those of you in law school, if you're reading, if in your classes you're reading the Kelo case from 2005, notice how Justice Stevens writes the majority opinion. He's totally apologetic. He's basically saying, my hands are tied. Berman versus Parker said this is what the Fifth Amendment is about. He even throws in a sentence, and this is important to know about land use regulation, because as I told you before, every state constitution has a takings clause, a due process clause, and an equal protection clause. And you, as smart planners and lawyers, now knowing that, can say, hey, does this violate the state constitution? Most people never ask that question. You'd be surprised how most people, including lawyers, never ask that question. And I'm telling you right now, it's an easier way sometimes to win a case, no matter which side you're on, if you just focus on the state constitution and not only on the federal constitution. In fact, the really smart lawyers, if they can win their case on the state constitution and never cite to a federal constitutional provision, then there's nothing that can be appealed to the U.S. Supreme Court because there's no federal issue. It's all decided under state law. I've been known to do that too, and it works. The point is, as I told you, it's a dual system. You know, when someone says to me something, that's unconstitutional, I am the nerd that says, well, which constitution are you talking about? And that's something you need to think about. You may not want to say it out loud, but always have it in your mind. Which constitution are we thinking about here? And often it's both. You can't go wrong with both unless you're in a jurisdiction where you think you're going to lose If you think you're going to lose, then maybe you want to have the possibility to appeal to the Supreme Court, because with the 9 of them, they could do anything. So again, I'm digressing, but that was Kelo, that's eminent domain. Okay, so page 2. Now I'm going to really start moving more quickly. This is state governments. As I mentioned, we've got the state enabling statutes. Just so you know, we just passed the 100th anniversary of zoning in America. Zoning came to America from Germany. There's a lot to be said for that. I won't comment any further. But zoning was invented in Germany in the 19th century. Bismarck, that whole gang. The Second Reich. And it was imported into the United States by the city of New York in 1916. So we've had it for 101 years. And New York brought it in to make sure that the hoi polloi down in lower Manhattan, down south of 14th Street, did not start marching up Fifth Avenue where the mansions were. That's why zoning came to America. The whole point of zoning is a separation of uses. Now that's a nice planning term that's used in all the planning schools. Zoning is based on the separation of uses. And I always go, well, what they're really talking about is separation of peoples. That's what's going on. Not that it ever happens in your hometown. I understand that. But that is zoning. The concept of zoning is to separate uses. Housing, single family, housing, multifamily, commercial, industrial, institutional, that sort of stuff. Those are uses. Retail, those are all uses. In the 1920s, when Herbert Hoover, who was not the FBI director, he was a president of the United States, Herbert Hoover in the 20s was U.S. Commerce Secretary. And when he was U.S. Commerce Secretary, a Republican, a conservative Republican, that was in the day when conservative Republican meant something totally different than it does today. Under his administration as Commerce Secretary, they wrote a modern zoning enabling act, and then they wrote a modern planning enabling act in the U.S. Commerce Department to be used as models for the states to adopt in the Union. Now think about that. As I told you, land use controls in this country is done at the local level. The federal government does not do zoning. The federal government does not do land use controls. Yeah, right. That's why my thing is titled American Development, State and Local, and yes, Federal, in parentheses, land use controls. But the history goes back to the 20s. The 2 model statutes written, one, a model statute for how to do zoning and a model statute for how to do land use planning, came out of the 1920s Commerce Department and was promoted to all the states. And the states began enacting these enabling statutes, one for zoning, one for planning. Now, since that time, as I note, a number of states, and these tend to be states on the coast or high growth states, they also do not just zoning and planning and subdivision control, they also will adopt growth management statutes at the state level to how to control and manage growth within their state. So as I said, zoning is all about the separation of uses. Planning is all about the city or county comprehensive plan, which is the vision, the guide for how the physical development of that jurisdiction will go forth over the next 20 years, 25 years. That's a typical time frame. Where should the roads go? Where should the parks be? Where are the conservation areas? Where do we have economic development? Where should be the high density development? Where should be the low density development? What should be the zoning that we then adopt to do all of that stuff? All of that is a part of the comprehensive plan. Sometimes some places call it a master plan and some places call it the general plan. Comprehensive plan is probably the most generic term. So they also will have at the state level, depending upon the state, a number of states will have historic preservation statutes. A number of states will have impact fees statutes. Impact fees are police power ways of extracting money from land use applicants. It's not an exercise of the taxing power. If it's the taxing power, the courts uniformly say across America, if you're going to exercise the taxing power, then it must be uniformly applied to all the like folks in that jurisdiction. And the power to tax is that power. But if you're going to have impact fees, that is a form of land use regulation. And therefore, you must have a closer tie between the impact fee assessed against a developer or project owner or whatever. There must be a close connection between the fee assessed and the impact of that project on the public. There has to be what is called the essential nexus. And this is required by the Takings Clause of the U.S. and state constitutions, because it's all done under the police power, impact fees are, not the taxing power. If you have the taxing power, and every government has the taxing power, you can tax to your heart's content. But if you exercise under the police power, you have a lot more rules that attach to you in this country. And impact fees, a lot of states have impact fee statutes, a lot of local governments have impact fee ordinances, and these governments tend to be either on the coasts or in high growth states. Then they're operating under the rules of the police power, not the taxing power. This is important to understand because most politicians don't know that, don't understand it, and a lot of them don't care. But the distinction is critical because when they do it the wrong way, if you're unhappy and you take it to court, that's why God invented judges, to tell the executive branch or the legislative branch, you did it the wrong way, I'm striking it down. So a lot of states now have wetland statutes, and not just historic preservation, but endangered species statutes, brownfield development statutes. All of these are different forms of land use regulation, and a lot of states will have independent statutes dealing with that. It's important to know that because a lot of people always think federal. They're always thinking, well, there's the Federal Clean Water Act with all the wetlands regulation that goes on, and that's all true. But a lot of states have their own wetland statutes. There's the National Historic Preservation Act of 1966. Covers the whole United States. Absolutely true. But a lot of states have historic preservation enabling statutes, which means a lot of their local governments have historic preservation ordinances. And so you always have to be always thinking, okay, I understand the federal stuff. What about what's going on under the state system that I'm in? Okay, never forget that. You'd be amazed how often people completely ignore the state scheme. Or the reverse. They're so focused on the state stuff, they forget the federal stuff. So it's just important, again, no matter what you're doing and who you're working for, to be aware you have two systems here. And when you're dealing with historic preservation, endangered species, wetlands, a whole host of such regulatory things, it could be under either system. Now, the thing I want to turn to now very quickly under the outline called local governments. Let me just say this about planning. Most states, every state has an enabling statute that says our local governments may plan for land use, have comprehensive plans. A lot of local governments don't do it, all right? If you're in a big urban area, they all have comp plans. But huge parts of the United States, depending upon where you end up working, huge parts of the United States, there is no requirement to have a local plan. Everything is done just by the local zoning ordinance and the local subdivision ordinance. Keep that in mind because in the vast majority of states where there is a comp plan at the local government level, the plan is deemed a guide, not black letter law. It's deemed a guide, okay? In some states, it's deemed more akin to law. That is, if the plan is so detailed and has all these restrictions in it, and it's implemented, therefore, by the zoning ordinance and the subdivision ordinance and the growth management ordinance and the historic preservation ordinance, not to mention the local budget in terms of where they assess money to be spent on this, this, and this. Well, then in some states, a comprehensive plan is getting real close to being law. And the classic example since we happen to be sitting in Washington, D.C., in Virginia, the plan is a guide. In Maryland, the plan is far more akin to law. If a plan is very general, it tends to be more of a guide. The more specific it gets, the more legal it looks. And in some states, it takes either the state court or the state legislature to say, okay, this plan now, if it's tied directly to the zoning ordinance and they link each other up, then the plan has legal impact. You must do what the plan says. It's not just what the zoning ordinance says. Now with zoning, I want you to keep in mind two things. Zoning, as I said, is all about the separation of uses. There are what are called zoning text and zoning maps, and they're different but related. If you live in a house and you grew up in a house and was sitting on a lot, and the lot, by the way, is a magic word, it happened because the subdivision ordinance said this parcel of ground is a lot recorded in the land records of the city or town or county. It is a recorded lot, and that's what subdivision is all about, recording lots all over the place to put a building on. In most jurisdictions, it basically means a building per a lot. And of course, there's exceptions. The bigger the project, the bigger the complex, you might have a bunch of buildings on a recorded lot. But let's get down to the easy stuff. A house is on a recorded lot. Okay, so that recorded lot is an exercise of the subdivision ordinance because they've subdivided the land into lots. Then zoning says, what are the uses that go on all those properties? Okay, and in the good old days, right on through the 1980s, the whole point of zoning was to separate the uses. Make sure that if you're living over here, God forbid you have a convenience store on the corner. No, we want you to drive 3 miles to the grocery store. Okay, that, unless you're in the middle of, New York City or Washington or San Francisco or Chicago or something, it's what really separates the big cities from the suburbs. The whole point of suburbs is to separate uses, big time. So in any event, with the zoning, you have the map and you have the text. The text is like any law that you ever dealt with. It's just they write down in the text, you're in the R60 zone, meaning residential, 6,000 minimum square foot per lot. We call that the R60 zone in some jurisdiction. And that, we lay out the rules. The house must be set back X amount of feet from the street, X amount of feet from the neighbor, can't be taller than 30 feet, blah, 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 all the zoning restrictions. And it tells you what the uses are. And basically they're saying, well, if you're in that zone, you can put in single family detached housing. That's it. No townhouses, no apartment buildings, nothing over 30 feet, no retail, no commercial, no industrial. That's what zoning is all about. That's the text. The map is literally the map of the jurisdiction of the city, town, or county. And on the map, you can look at the map, just look at the map, and you can say, oh, my property right there is zoned whatever. R for residential, I for industrial, C for commercial. And the map is always in color. And across America, one thing is consistent, the colors. All right? So, green means one thing, red means something else, yellow means something else, gray always means industrial. That's the map. So you always have to know if you're engaged in a zoning issue, you've got to ask, are we dealing with the zoning text or the zoning map or both? Because the government, the local government could change either or both. If you hear the term, I just got downzoned, I want to sue the sons of this, I want to sue them. They just downzoned me. Downzoning means they took what you had and took away a lot of what you had. You could do all this stuff and now you can do very little. That's a downzoning. You got to figure out, did they do it by a text amendment or by what is called a rezoning, which means they just put you in a different zone. This is important to understand because government does this to people every day, and people often don't realize what's happened to them until it's too late. But this assumes that the government did everything according to Hoyle, and provided you notice and an opportunity to be heard. I got a phone call 2 days ago from a group of lawyers in a major jurisdiction in the Washington region, in which a certain jurisdiction completely rezoned a big chunk of the jurisdiction, and they noticed it's going to cover just this little area over here, but by the time they got done with their action, they said, nah, we're just going to do everybody. And it was like, was there a problem here? And it's like, well, let's talk about procedural due process, notice, opportunity to be heard. None of that happened. Oh, there was notice, but not adequate notice. So you can see how the issues happen. Did they do it by a text amendment or a map amendment, or do they do both? It makes a difference, all right? Because if it's done by text amendment, then that means they literally are doing a legislative act. They're changing the text of the law. If they do it by a map amendment, it's also a legislative act, but they can move a lot faster. And so depending upon what you're doing in your practices and in your work as planners or lawyers or whatever, you need to keep in mind, what are we dealing with here? And did they follow the proper procedure? Because zoning is all about map and legislature. The map and the text. Now, here's the other huge thing to keep in mind. Courts have always said, well, zoning actions are legislative acts. Therefore, the courts give deference to the local legislature that did that zoning thing. Whether it was a text amendment or a map amendment, it's a zoning thing. It's legislative. We give it deference. You really got to say that they were really horrible about what they did. Clear violation of substantive due process, clear violation of procedural due process, maybe a taking, maybe a violation of the Equal Protection Clause, or they just violated the local ordinance, the very words of the ordinance. They just ignored them. And by the way, this happens all the time. They often just ignore the words of their own ordinance. Never forget rule number 1. Check and see what the written law says. They often either forget about it or blow right past it. They often will ignore what the state law says that they can do. They just ignore it. They usually don't know it exists. Really, they never pay attention to the state enabling zoning law or the state enabling planning law. And they get in trouble, local governments, all the time by ignoring what the state statutes say that they can and cannot do. But here's the exception to always know this. It's an exception to every rule. Courts across America have also said, however, if local government does something to just like 1 or 2 property owners, they use their zoning power just for that property right over there, then that doesn't look like a legislative act. Even though they're acting as the legislature to do what they do, this is when the courts say that looks like a quasi-judicial act. And what that means is that the government now has a higher burden to justify what they've done. It means the property owner who's complaining has an easier time saying, I got targeted. And this thing about, is it a legislative act or a quasi-judicial act, is constantly happening in zoning matters all across America every day, just so you know. And by the way, even though New York City adopted the first ordinance in 1916, the first zoning ordinance, the U.S. Supreme Court, just 10 years later, in 1926, said in a famous case that came out of the courts of Ohio called the Euclid case for a suburb of Cleveland, the U.S. Supreme Court in 1926 said zoning is kosher in America. It's constitutional. Local governments have the power to zone. They can't violate constitutional rights, but they have the power to zone. And that decision by the Supreme Court in the Euclid case of 1926 is what all the courts have followed since then, in the sense that zoning can do what it does. It just must follow the constitutional principles. Now, let me just touch on federal government a bit. Well, before I do that, I should touch on just subdivision just for a moment, because subdivision ordinances are separate from the zoning ordinance and from the ordinance dealing with adopting a comprehensive plan. And the subdivision ordinance, as I told you, is all about the creation of lots to put stuff on. And with subdivision ordinances, virtually every local government in America has a subdivision ordinance. They really do. they have far more subdivision ordinances in this country than they have zoning ordinances, and far more zoning ordinances by far than planning ordinances. So when you're dealing with these issues at the local level, you just got to be aware always, despite what the state laws say in terms of enabling, you've got to be aware of which ordinance are we under here, because they're different. And sometimes they interact with each other, as you could possibly imagine, but sometimes there's a very distinct power of subdivision versus zoning versus the plan. So with the subdivision ordinances, those cases and those issues tend to be relatively small bore cases. The bigger cases and the bigger fights in this country at the land use level, whether it's in a city, a county, or a town, are the zoning battles that go on. And the project development battles, and that's tied to planning as well as zoning. Federal government, as I know, a lot of ground in this country is owned by the United States government. In fact, it's 29%, and most of it is out west. It's definitely west of the tier of states, west of the Mississippi River. That's where most of the federal lands are. But it's important to know as practitioners and planners and wherever you end up in your careers that the federal environmental statutes that began to be enacted in 1966 right on through 1973. I mean, when I say 1966, I'm starting with the National Historic Preservation Act. It's not a pure environmental statute, I know, but everything began with that in 66, and all this, Clean Water Act, Clean Air Act, they just kept coming. The Coastal Zone Management Act of 1972, the Endangered Species Act of 1973. All of these laws were being enacted between 1966 and like 1973. Well, the federal government often says right in the statutes, we're not doing zoning, because the battles in the Congress was, hey, a lot of this stuff smells like zoning. When they enacted the National Environmental Policy Act, NEPA, in 1969, when NEPA was enacted in 69, a lot of people don't realize there was a parallel statute before Congress at the same time. There was the National Environmental Policy Act, and then there was the National Land Use Policy Act. And they were going to have a national land use statute, federal, and NEPA on the environmental side. The only reason the National Land Use statute, the votes were there to do it. The only reason it didn't happen was because of Watergate scandal. The administration was so involved in defense on Watergate that once NEPA got enacted, and Watergate was later, but National Land Use Statute was going to come afterwards. They just couldn't devote time and resources to that fight. And so NEPA got enacted in 69, took effect in 1970. The National Land Use Statute, which was supposed to follow, and it was following the same trajectory, and it had support in both parties. Again, it's hard to explain to people, but before 1980, the federal congressional presidential system was so different than it's been since 1980. But back then, it had bipartisan support, and it was going to happen. But in the end, it never did. It all fell apart because of what came later, and they just couldn't devote time to it at all. And everything fell apart with congressional support on everything that was going on. I mention all of this because there's all this language in these federal environmental statutes that are basically saying, well, we're not doing zoning. But reality is, when you see how the statutes work, they're engaged in local government regulation, especially when you're dealing with wetlands regulation, because as practitioners, you will learn this. The local regulators work with their state regulators who work with their federal regulators. And that's the way of the world. If you're in the biological unit of a local agency, you're going to be very aware of the state biology world and working with the state regulators under the state law. And then those folks at the state level are doing the same thing with their federal counterparts. And this happens especially with wetlands regulation, endangered species regulation, and of course with clean air. It has to be that way with air. So this goes on all the time. Now, one of the principles that you will learn is, and this is an important principle to know, that despite all of that, every person at any level of government really dislikes anybody from the next level of government telling them what to do. And the local people really don't like being told by the state people, you must do X. They don't like that. Just like the state people don't like being told by the federal people and the federal agency, you must do Y. They don't like that. So where they can work together, they do, but they don't like being told you must do this and you must do that. But the point is that all of that interaction is going on. And so regarding Clean Water Act in particular, that is deeply involved in local land use controls. And a lot of what you may end up dealing with is the issues raised by local, state, and federal disputes and tensions on things like water conservation, wetlands, endangered species, historic preservation, all of those kinds of issues in which there's a federal law and a state law and the local ordinance, as well as the local comp plan. Because if the local comp plan says this area should be set aside for conservation for the following reasons, you're automatically kicking in, if you think about it, what do the state laws say about how to preserve that conservation area? What do the federal laws have to say? And it ain't necessarily so that the local, state, and federal people all agree with each other. There's one thing that's different about the people at the local level vis-a-vis the people at the state level to the federal level. The lower the level of government, the more they're deeply concerned about the tax base and economic development for their town, their city, their county. The higher up you go in the governmental system, to the state level, to the federal level, that concern lessens. And those tensions come out all the time in the entire land use regulatory system of America when you have the state involved and sometimes the federal involved. That happens under Clean Water Act issues. It happens, I mentioned wetlands, I mentioned MPDES permits, state water quality certifications, all of these federal requirements that are done under the Clean Water Act, endangered species, the Historic Preservation Act, NEPA, oh my gosh, NEPA. No matter how many NEPA matters I work on, you spend most of your time mediating among the three levels of government, the local, the state, the federal. And you spend a lot of time just mediating to get through the process. And all of this impacts what goes on at the local land use level. But federal government doesn't do zoning, federal government doesn't do subdivision, federal government doesn't do a comprehensive plan for the local government. But when the local comp plan says these are the public policies we're advancing, there could be federal and state laws that help do that, as well as the local ordinances. And that's where you have these gray areas. And as practitioners, your job basically is to just be aware of all of that, have that knowledge base so that you can help whoever your client is, whether it's public or private, get through the process. The hardest part in the American land use system is getting through the process because it's so darn complicated. And when people get stuck at the local level, when I say people, I mean whether it's an applicant trying to do something or a third-party group trying to prevent something from getting done, the more they get involved, the more you will always hear, this is so complicated, and they never taught us all this in planning school or in law school or whatever. And because you're really dealing with human nature at the most visceral levels. And so the last thing I want to touch on is the end of the outline, this statute that so many people don't know about, especially at the local government level. And it's called the Religious, I know it's got the longest title, and it's just a mouthful, it's so cumbersome. The Religious Land Use and Institutionalized Persons Act of the year 2000. We call it RLUIPA. When Bill Clinton was president, RLUIPA was enacted and Clinton signed the bill, RLUIPA is the closest thing we've got to a federal statute that trumps local land use regulation. And the vast majority of local land use people, meaning regulators, planners, and local government officials, know nothing about RLUIPA until someone such as yourselves, who are aware of it, are sitting there saying, you know, you really can't do this because of, and then the first thing they say was, well, federal government doesn't do zoning. And then you go, well, that's true, but there's RLUIPA. RLUIPA was enacted because it came to Congress's attention that too often local governments were using zoning controls to zone out group homes, homes for discharged prisoners, bringing them back into the community. Also, they were using their powers to make it very difficult for houses of worship to establish themselves in the community. So Congress, taking all of that into consideration, passed this statute, which is why it's called Land Use and Institutionalized Persons Act. It's really about group homes and houses of worship and that sort of local land use. And what it is all about is this. The local government is sitting there. There's the planning commission having a hearing, or the local board of county commissioners, or the city council, and they're having this hearing on a zoning application to build this thing over there in that part of town. And it turns out that neighbors come out and oppose it. And the it could be a house of worship. I will use church as shorthand for house of worship. And the neighbors are saying, you know, these churches aren't like the neighborhood churches of the Mayberry days. Now they have enormous side uses attached to the church. It's not just a house of worship. They've got an Alcoholics Anonymous center. They've got a daycare center. They've got this, that, and the other. And they have acres of parking. And it creates an enormous traffic. These things are huge. They're enormous institutions. And as we all know in the land use game, if you're a house of worship, you can be in any zone. The First Amendment, the way it's been interpreted by the courts, is you can have zoning, but you can't zone out houses of worship, as we got this thing in the First Amendment about free exercise of religion. So this is an example of how a constitutional provision can trump a zoning ordinance. And so this has been interpreted to mean, well, you could put a church in the middle of an industrial area if you want to do that as a church. You can do it. You can put it in the middle of a neighborhood of houses. You can put a church anywhere. You can't zone them out. But what happened increasingly is local governments would say, the impacts of this church are so huge that we're just going to say, we're going to attach all these rules and conditions to it so that it can only be this big, and the parking lot can only be this big because you can only have so much traffic coming in down the neighborhood streets, and you can only do this much and blah, blah, blah. And that is what led to, as well as the group home provisions, that local governments kept finding ways to use zoning to zone out group homes. This is how RLUIPA came to be. And so what RLUIPA says is this. It says where local zoning makes it a really tough time for a house of worship or any institutionalized person's proposal to come into that part of the city or county or town, the law says that the local government cannot impose, and these are the words right from the statute, they cannot impose a substantial burden on that proposed land use unless, one, there's a compelling governmental interest at stake, and two, the local government has used the least restrictive means possible to deal with that compelling public purpose. The minute you have, I will just tell you, the minute you read an ordinance or a statute that uses the words compelling or least restrictive, you are in shark-infested waters, people. Just know that. As well as substantial burden. And so since this law was enacted in 2000 and local governments are slowly waking up to it, when a knowledgeable planner or lawyer advises the local planning commission, city council, whomever, they can sue us under this federal statute and they can really get us for damages. And oh my God, it's just the liability would be terrible. The Supreme Court has made clear in its decisions since this statute was enacted and the lower federal courts have been uniform, they have really come down hard on local governments that have been using zoning to zone out churches, temples, mosques, group homes. The local government defense always is we're not zoning out the use. It's just a mere restriction on use. It's just a few conditions. But the Supreme Court has said in these cases, the Nolan case, the Dolan case, the Kuntz case, conditions on use, and this is the third regulatory takings test you see in the outline, conditions attached to a use, even if you approve the use, the conditions must also meet constitutional muster. You cannot attach conditions to a use that you're approving in which the conditions are not closely connected to the impact of the proposed use, and in which the condition must be directly proportional to the impact of that proposed use. That fundamental principle of a direct connection and proportional impact underlies all of American land use regulation today. And this comes from the state courts and now the U.S. Supreme Court. And the RLUIPA statute from 2000, that's the theme of the RLUIPA statute. So you need to keep those restrictions in mind so that the bottom line is that local government has unbelievable power, which is why so many suburbs look the way they do. So they have remarkable power, but it is leavened by the state constitution, the federal constitution, and the court rulings of that state as well as the federal courts. And as planners and as lawyers and other kinds of professionals in this game, as long as you're aware of some of these fundamental principles, you'll be fine. And just exercise a rule of reason and always beware of the mob. And that is what they are at 11 o'clock at night in the hearing room. The group of concerned citizens by 11 o'clock turns into a raging mob. And local officials, if they're elected, get very nervous and will do the darndest things that then put you're trying to advise them, in a difficult position the next day when you get the phone call from the lawyer who's unhappy about what they did the night before. That's it. If there are questions, I'm happy to take, even on something I never talked about,
Great. So let me get you the microphone if you have one, but I want to go first to one that came in through the web. This is a question about a specific executive order, EO 131332. Do you know it?
Which one?
It's on federalism, signed by Bill Clinton in 1999.
So he's for federalism.
I'm not familiar with it, but that's the question. Greg, if you're still listening and can clarify, we'll come back to your question. If we'll go to one in the room.
Oh. I was just going to say, is this the executive order on wetlands? Is there any additional information there? Because maybe.
I off the top of my head and look it up, and it's really about federalism and all that.
If it's about the federalism of wetland, yeah, I just was hoping to clarify.
If he's still listening, we can get him to clarify. We'll come back to it.
I had a question following up on some of the eminent domain and the developments post-Kilo. Do you think any of those developments might play out with some of the recent cases regarding oil pipelines that are being, not necessarily DAPL or Keystone, but there's all kinds, as I said, I'm from North Carolina, going through?
Right. Well, I think since the raging debate in the post-Kilo world, governments are really attuned now to what they should and shouldn't be doing, so that when they exercise the eminent domain power, from what I've been observing since Kilo, they're being a lot more careful about how to do it, because there have been enough written about what New London did to point out all the mistakes the city made in that particular case, not to mention what the Supreme Court had to say in the majority and dissenting opinions, that from what I've been observing literally since Kelo is that local governments have been doing a much better job in using their power of eminent domain.
I'm wondering if you could talk about the conflicts that you see or overlaps between city and county governments, because I'm from one of the very few cities where the county owns the roads and the city can't do anything with the roads, and so there are always these raging conflicts between city and county. So I was wondering if you could talk about that overlap.
And which state are you in?
Boise, Idaho.
Idaho?
Yeah.
So regarding city versus county, let me approach your question from this way. The Mason-Dixon line really divides not just the free states and the slave states, okay, but it also divides the way local governments are set up in this country. You're north of the Mason-Dixon line, like you're in Pennsylvania or New York. Counties are really weak, and it's the cities, towns, the water district, the school district, sewer district. There are multiplicities of these municipalities and districts within each county, and they all have unbelievable amounts of power under the state law. South of the Mason-Dixon, and California is the same way. South of the Mason-Dixon line, the counties are very powerful. In fact, there are big counties south of the Mason-Dixon line in which there isn't a single municipality in them. The county is all powerful, in which there's one school district, one police department, one library system. I say all of this as background to answer your question. If Idaho is more like the usual, where you have this balancing of power between the city and the county, then the reality is, and this gets into annexation fights all the time, this is where state law is paramount. The state law in every state literally dictates what the balance of power shall be, and gets down to fine-grained things like if a city or town or municipality wishes to annex some territory within the county, you must do the following 3 things or 12 things or whatever. State law in every state is very specific about the balance of power between the municipality, whatever it's called, village, town, city, and the county. So it's so state specific that there is no general answer to your question. That it's literally, that is the one thing that is totally dictated by state law. I will say that a lot of municipalities don't fully appreciate that, and they will often do things that are in blatant violation of state law. Then the county or the state will take them to court and win. And that happens.
Eminent domain confuses me tremendously. And one of the things about it is the public use. And can you talk a little bit about what makes up a public use, like your cable TV example? Was it the access to the amenity, or was it the taxes that the company's going to pay for that access?
Again, as far as the cable facilities, if you can have a scenario where something physical is going on, then you're not in the eminent domain world. You're in the inverse condemnation world, and that's a physical invasion. So that's on the regulatory takings, physical invasion side of the world. On pure eminent domain side of the world, public use, until Kelo, public use in this country meant public purpose. But a lot of states did not follow that rule. But at the federal level, it was public use means public purpose, which means, and the court had said this over and over again, whatever the legislature said was the public purpose, the courts give deference to that. So they gave great deference. By the time of the Kelo decision, when you read what the 2 opinions say, you can see that the court was deeply troubled by all of that. But the reaction to Kelo was so many states, either the state Supreme Courts or the legislatures, retrenched and began to say, no, public purpose is too broad a term because it often is used to transfer property from private party using the government power to another private party. And there's something wrong about that because that's not pure public use. It's more public purpose because you get more jobs are created for your people, more taxes created for resources that you want. All of that, that's all public purpose, but it's not public use. Public use has always traditionally meant literally it's used by the public and it's owned by the government. Okay, that's the simplest test of all. The government owns it. The highway, the library, the park, the school. The government owns it. It doesn't matter what government it is, of course. The government owns it. The public, in other words, the people own it, right? Okay, the public purpose side is a lot grayer, as you're pointing out. And that's why the courts have been so divided. And that's why when you got to understand, the Kelo case was just symptomatic of this thing that was bubbling below for many years. And it exploded in this case in 2005. But what Kelo brought out is the fights that had been going on across the United States and state after state after state. Even in California after Kelo, even in California, the legislature, and this is California, they eliminated state redevelopment agencies, which were using the public purpose idea to take property in order to redevelop it into a higher, more tax beneficial use. And even in California, they said, we've taken this too far. And so I think what's going to happen is what's been happening is that you see as the eminent domain power has been used in recent years by local governments. It's what I said before. They're being a lot more careful. For example, if they're going to say, and this is what they're doing now, they're saying, if we're going to even try to go towards the public purpose side and not pure public use, then we have got to have a clear plan that has been vetted and adopted, and if it's tied to a development company or any company that promises to come and do something there to create more jobs for our people and more taxes, you've got to get that written in blood, really, because in Kelo, none of that happened, you see, which is why Pfizer was able to say, the market has changed, we've changed our mind, goodbye, City of New London, which is what happened, which left a bad taste in the mouths of a lot of people. I mean, even the New York Times wrote these scathing editorials about this is taking public purpose too far, but not because the concept is so terrible, but because the way it's implemented too often at the local level is just too loosey-goosey, and too many people get hurt. And that, and by the way, I'm a big film person. This is being turned into a major American film. Kelo is going to be, I think that I read from my thing from the American Film Institute, I think there's a movie that either it's coming out soon or it's in production, and I think it's called The Little Pink House, because that was Suzette Kelo's home. When a lot of these cases that I talk about, I've been involved in a lot of these cases, and I've been to a lot of these properties over the years. Because I've been doing this since '74. I mean, so I'm a troglodyte, all right? But you went to see her house. It was the damnedest thing. She had this little beautiful pink house with flowers all around it, and it was sitting in an island that had been cleared because everyone else had sold out to the City of New London. They all sold out and moved away, and she just said no. And so you went there. It was the damnedest thing you ever saw. And she had great waterfront property. That was the other thing about it, is she had great waterfront property and a lovely little pink house. It got moved, and in the end, I think might have been destroyed, but it was moved. So the movie, they had to recreate it because the house is not there on that little recorded lot anymore.
Great. I want to go to one from the web. Keith is asking about the ability of state governments to roll back municipal or county powers that they are granted.
Yes. This is the most fun thing of all. When you explain to a local mayor or council or board of county commissioners, about the state has the power to take all your power away, they can't believe it. I mean, because most of them are little Napoleons. Come on, that's who they are. And they can't believe it. And it's like you have to say, this local government, I won't refer to a name, but this town of whatever, or this city of whatever, is under the law a creature of the state government. The state created you, and the state can take all your power away. Absolutely, it can be done. It goes back to a fundamental principle I said, that there's only two sovereign governments in the whole United States of America, the federal government and the 50 state governments. No local government in this country is sovereign. Its power derives from what was given to it by the state, and the state can take it all away. The state can wipe out the government of the city of New York if it wants to, which is how, if you think about it, when you read in the paper about in New Jersey or whatever, or in Michigan, they took over the school system of Newark, or they took over the water system of Flint. Well, what you're reading is, yeah, because all of that stuff was created by the state and can be taken away by the state. Now, you got to be careful when you say this sort of thing to a local person. Always be respectful and grim looking. Never smile or smirk. You know, it's like you have to convey that this is a tragedy. I agree with you, Your Honor. This is like Hamlet all over again. Though I prefer to compare it more to Richard III.
That makes me wonder quickly, are there any differences with tribes? Have you done any work on tribal land?
I have never dealt with tribal issues. And, you know, all I can say about that is so governed by federal statute and the treaties that it's really sui generis. You know, the federal statutes make real clear about how the tribal lands are to be treated and the tribal peoples are to be treated, and the treaties according as well. So it's just, you know, as you know, they have remarkable powers, including judicial powers, on their territory, except where the sovereign power of the United States says otherwise. I have never had a zoning or land use matter on tribal territory. I mean, I have dealt with Berkeley, California. I have dealt with Tacoma Park, Maryland. I have dealt with all kinds of stuff, but never tribal. I will say this, for historic preservation, you know, God forbid if you're representing someone and you're working on a site to develop something and you come across an old cemetery. All you're doing is your client is praying that it is not a tribal cemetery from indigenous people or from American slaves, because they have special protections. And you're always hoping, please let this be 20th century white people buried here, because otherwise you're going to be engaged in a very long process, And the moment these things, you come across this on a development project, you bring in the appropriate historic preservation consultants and archaeologists to figure out. And this happens more often than you possibly can imagine. People are buried everywhere. And if you think about it, the more urban we are, the more that ground gets disturbed and being dug up. This goes on constantly. And you need to be attuned to the fact that the minute this happens, you need to bring in the consultants to figure out who is here before any action is taken. And of course, you have the SHPO involved often. You need to contact the State Historic Preservation Officer under the National Historic Preservation Act. And so you have all of these things that you want to kick in as well. So I know I digress, but that tribal question triggered the thought about that is a particular use that people are increasingly running into as they keep digging down in areas that we are becoming closer together on. It's not just all the greenfield stuff out there. And when you do that, did you all see the movie The Gangs of New York? By any chance, the Scorsese film, the terrific Scorsese, you saw that. Remember the very final scene, which is very well done, in which all of that stuff that happened in the 1860s. And the final scene is he has where they're all buried on the ground, apparently in Brooklyn, the way the shot is taken across the river towards Manhattan. And the way Scorsese does it is to show all these people, the black people, the Irish people, all these people who were fighting and killing each other in New York in the 1860s, they're all buried here. And you see, as the decades roll by, the way he does the end of the film, it's a terrific movie, Gangs of New York, you see what happens to the cemetery. And it's the classic case of, after 125 years, someone comes in, buys the land, no one realizes that it was ever a cemetery, and they start digging. Of course, that's also a great, the poltergeist, where, that movie, right, where they're taking over the house, and it turns out because they're developing in an old cemetery and all the ghosts are coming out. I have never encountered ghosts in any of my matters.
This is related to the question about tribal land, but I know a lot of really key laws are waived around the region of the border wall. And yes, and the administration's proposed expansion of the border wall would, of course, cross both tribal lands, public lands, and private lands.
Right.
So what do you think about it?
When that wall got proposed, and you saw where it was, right? Where you see where the wall is, here I am, a land use guy. I looked at that and said, this ain't going to happen. It's like eminent domain explosion in your head because it's all those lands. And have you seen what's been going on about all the property owners? It's classic eminent domain story. These property owners are saying, no way. The irony of ironies is that if you notice who the president is who's proposing it, this is the same person who has availed himself of the public purpose interpretation of eminent domain to get away with murder for a lot of the stuff he developed and built in Atlantic City and New York and blah, 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 blah. So he sees nothing wrong with any of this stuff. But what I love about what's going to happen, and you've put your finger on it, the details and the budget, the eminent domain compensation that would have to be paid to all these thousands of property owners who are screaming, you can't get away from the courts. God bless the third branch of government, because as nutty as the other two branches can be at the local, state, or federal level, all three can be nutty as heck. Thank God for the courts, because the courts are going to say, well, go ahead. You got to exercise eminent domain. And then, just so you all know, when you do eminent domain and you're figuring out what the value is of the property to be condemned, that is in front of a jury. And you know what juries do? They put themselves in the position, not of the government, they put themselves in the position of the property owner. Therefore, for the grace of God, they could be taking my house, my farm, my corner store. I have no idea how they're going to pay for all of that. I really don't. This is why I just laugh. Because let's face it, the other two big walls known to world history, right? The Berlin Wall, I remember the day that thing went up in 1961, and the Great Wall of China. And the only way they got built was by dictatorships. I don't know how they're going to build this wall in Mexico. Plus, I can't wait when he sends the compensation bill to Mexico. Because I don't think Mexico is going to be a condemnee. I don't get it. I really don't get it. I guess it sounds good. Look, I get through the day every day by watching CBS between 11:35 and 11:45, Monday through Friday at night. That's all I'll say.
So my question is in the context of regulatory takings, and I was wondering if there's ever been a case or an argument that federal government inaction to have a regulation is a form of a regulatory taking to someone's property.
Good question. Yes, and it gets to these kinds of cases where you have the interaction of federal government with state or local government in some regulatory way, like wetlands, all right? Then you've put your finger on something really fun and interesting intellectually. That's where the discussion at the table is, all right, who do we sue and in what court system are we in? And here's the short answer. When you're ever faced with that, you sue them all. Really, you sue them all, and then you let it all play out and see what the judge rules about who are the proper defendants. But yes, there have been cases where you have a federal agency and a local agency, and you're saying, well, geez, we got federal and local. Should we be in the state court system or the federal court system? You know what? Just pick one. It often depends upon what state you're in. If you're in California, then, you may as well slit your wrists either way, right? So it's like 6 of one, half a dozen of another if you're representing the property owner and you're going up against a regulatory thing. But the point is if it's like a federal and local or federal and state, figure it out, make sure the complaint clearly lays out why you're naming that defendant. This is what they did. And then what happens, you see, is in those cases, this is what happens. They do this. Hey, this is what happens. The feds will go, hey, it's not us. It's those stupid local official people. They're the ones that did. If anything bad happened, we're not admitting anything bad happened. This is the way all these cases are. We don't admit anything bad happened, illegal, unconstitutional, fattening, whatever. But if it did, it was the locals. And the locals are saying the feds made us do it. And yes, in those cases, you just have to be very clear about what each player did. But there are those situations. It happens in some regulatory contexts where you have 2 or 3 levels of government all being defendants. And the courts figure it out. They really do.
Time for one more in the room. I have one to wrap it up. What do you think issues with climate resilience and adaptation are going to mean for land use in the next 20 to 50 years?
So after the Pence administration?
I'm thinking about entire towns in South Louisiana that are already being planned.
I do not understand people who keep building houses on barrier islands. I don't get it. And the fundamental flaw in the American land use system is the federal flood insurance program. It's the federal flood insurance. Congress came very close several years ago, to answer your question, of getting rid of that provision of the program, that core provision of the program that actually incentivized people to keep building in these unbelievably dangerous places right on the coast, right? And that Congress came so close to getting rid of it. But because we're a democracy, those people on the coasts, that's a lot of people, that's a big part of the American population, in a lot of states, therefore a lot of senators, scream bloody murder, and they pulled back at the last second. We came so close. So I think as long as that statute is there, that we incentivize people to keep building there, they will keep building there. And it's the classic example of human nature that until the Pearl Harbor happens, until the Hindenburg blows up, until something like that, literally, it's not enough to have a Katrina. They will keep doing it. But this is where I blame the federal government for incentivizing all of that development. And the local governments can't help themselves because they look at it as a prime way of getting taxes. So they have an economic incentive at the local government level because those properties are deemed valuable. Therefore, they throw off a lot of tax to the local government. So it all comes down to the money at all levels. But I think the time will come where they will, once they get rid of that core provision of the federal flood insurance statute that they came close to doing, I think then that nature will take its course and they'll stop rebuilding in these places that get knocked down every 10 or 15 years. I just think it's, it's not going to happen now, but I really think it's going to happen, and I have no idea when. I depend on you people. For those on the webinar, everyone I'm looking at has got to be 40 years younger than me.
All right.
I depend on y'all doing it.
Well, thank you very much. Everyone, please join me in
You're
thanking
welcome.
us for being here. We appreciate your time, and thank you to all of our participants today, both in person and online. Hopefully we'll see you next week. We are on for July 6th, even though it's the holiday weekend. Enjoy your 4th of July holiday, and we'll see you next week.
Thank you.